Begin.
Good morning. May it please the Court. I am Robert Bender, Assistant District Attorney for Middlesex, appearing for the Commonwealth. The Commonwealth here appeals the allowance of a motion for new trial prior to the appeal of the murder conviction of Eric Murray, who was tried in January 2005. The trial judge relied here on an affidavit of Framingham Lieutenant Kevin Slattery, filed 29 months after the trial in federal court in connection with pretrial detention of several Framingham defendants, some of whom, or all of whom, belong to a gang known as KST. It was looking at this affidavit alone that persuaded the judge that the Commonwealth had failed to turn over what could have been exculpatory evidence regarding what Framingham police knew at the time of the trial 29 months earlier concerning KST, finding that that evidence may have done two things. One, it could have helped the defendant raise an adigent-type challenge, seek to be able to introduce specific prior acts of individuals, even though he didn't know about their bad acts, in order to show that they may be first aggressors. Now, the trial of this case was 2 months before the adigent case. That was not the defense that was raised, and the judge so concluded. But the judge erred when she went further and said that the Commonwealth should have anticipated adigent coming down and therefore made discovery as if that was the law. And the trial wasn't held, and so the trial was 2 months before adigent. Discovery was completed long before for this October 2003 murder. So it's error to have, and I say to have relied at all on adigent and its prospective application in this case. It certainly wasn't fair or the law to require the Commonwealth to anticipate a case that wasn't a burden on the defendant to anticipate and to raise a trial in anticipation.
But wasn't the judge discussing adjutant in connection with the non-new part of the law relating to whether a defendant may offer evidence of a victim's violent character to demonstrate the defendant's state of mind, as opposed to which can go in through not just evidence of violent acts, but reputation evidence as well.
It is the reputation.
And as to the new aspect of adjutant, I thought that Judge Hamlin said that wasn't applicable here. And so that, you know, I don't really see that adjutant made much of a difference to the judge's ruling.
Well, the judge spent a considerable portion of her ruling discussing adjutant.
Yes, and saying why it didn't apply.
Well, she said that the defendant, she concluded the defendant did not raise an adjutant type of defense.
That's right. And so that's not the basis for her decision to grant a motion for new trial on the basis of this affidavit. She said this affidavit could do other things.
Well, the affidavit, she as I was going to continue, she also turned and spent, you know, not as much time, but certainly as much weight to how the affidavit could be used for impeachment of the witnesses, regardless of what type of defense was being used. But I just want to complete what the court was asking about the adjutant case. The critical difference here is before adjutant, a defendant could introduce what the defendant was aware of as far as the reputation and what the defendant was aware of as far as specific bad acts by those who were confronting him if they want to show that the other person, the victim here, was the first aggressor. And in this case, the defendant introduced nothing along those lines. There wasn't any doubt that the defendant knew the victim and knew several of the other people that were there, but he didn't offer anything on a basis of who was the first aggressor based on what he knew. And there's no allegation that the Commonwealth failed to turn over not only the statements of all these witnesses, but their full records, including that of the victim, as to what was there. What is being hinted at is that the Framingham police, over the course of the years that followed this murder, developed quite a file on people who were in KST. However, what's in the affidavit, which is what the judge considered, the affidavit only mentions the people who were involved in this trial in a way that doesn't really show anything as to the general allegations.
But do you contend that this evidence would be admissible only for the showing of first aggressor?
No. No.
I mean, that's, I don't think, what the judge was getting at. I think it's, that it may be admitted to prove that at the time of the assault, the defendant was reasonably apprehensive for his safety and used a degree of force that was reasonable in light of the victim's violent tendencies.
Well, in a pre-adigent state, it would have to be based on the reputation of these people that the defendant himself had. It's not something that he was unaware of, as in the Pring-Wilson case, where the defendant was unaware of who it was he was dealing with, but he tried to raise information to show that the
But this
police
defendant
knew.
did know these people.
This defendant does know these people quite well, and did not raise anything of that nature.
Wasn't he saying, though, that he was, wait, he didn't testify, I don't recall.
No, he did not testify. He made a fairly complete statement, though, to the state police.
But wasn't his approach that the victim was trying to rob him?
He said to the state police that...
And that there was a whole group of people there. And so that's when this business of whether or not they were a gang or just a sort of basketball team might make a difference.
Well, let me look at this a little bit from just the general impeachment, because what the defendant, according to the judge, could have done if they had more information about the KST gang in general is come up with a theory that's not in that information that supports his statement that they were trying to rob me, or not they, specifically the victim. The victim and the defendant met a few hours before at Beaver Park, where one of the witnesses at trial, Randy Lopez, had the defendant's girlfriend or his own girlfriend's dog, and there was some pushing a little bit. And the witnesses at that time to that incident are Randy Lopez and Jerome Jones, who were two of the three people who went with the defendant to Kendall Street that night. So these are witnesses who the defendant didn't try to impeach at all, and they really were pretty much, well, this was kind of some kidding around type of thing. It wasn't an attempted robbery or anything like that. The defendant said that his relationship with the victim was that the victim is someone who he buys marijuana from, and it was just kind of lip, I guess, or talk, and not seen as anything serious. We don't know.
Mr. Bender, excuse me, but wasn't the general idea here, at least presented by the Commonwealth, that KST was some type of harmless collection of people who happen to know one another? And then doesn't the affidavit shed some light that this was a gang, that it had a reputation for violence? It was more than a group of friends?
Well, it's a bit more to it than that, Your Honor.
Isn't that what the judge looked to?
Well, that's what the judge looked to, and I'm saying that the judge erred in what she did look at, which is Lieutenant Slattery's affidavit, and what she didn't look at, which is the information on which his affidavit should have been based. That was the 280 pages that I filed with the court.
But that wasn't submitted until the motion for reconsideration.
It wasn't, because the Commonwealth took the position that the affidavit itself, while it made some general statements about a KST gang that was being investigated in the years later, that affidavit didn't make any specific allegations regarding the victim, other than he was shot and killed. It didn't say anything about Anthony Campbell, who was the only one of the people who said he was in KST, who said, the defendant, I saw him, he's the one who did the shooting. It says nothing about him, and if you look at what the Framingham police have as far as information as Anthony Campbell, he has no record at all. Yet he says he is a member of KST, and he says that it's not, as far as he and his people are associated with it, is not the kind of a gang that Slattery is talking about. This is sort of part of the problem, is time passes, and who was there on the street in 2003 is not, and quite literally, is not the people that Slattery is talking about are causing all the drug damage and trafficking. They're not the people who are being picked up in the investigation. Now, there is some coincidence of names. I can't hide that, and I told that clear to the judge. One person is James Salvey, who was indicted. But James Salvey, all the evidence is, was not there. He didn't see what happened. He didn't testify at this trial. So it was impossible to impeach James Salvey or to hold against him any of the things that happened after the trial. The allegations, the federal allegations as to him, are things that happened after the trial. Another person is this Emmanuel Asamwani, who was indicted. It said that he was on the street, and that's it. He was interviewed by the police. His statement was turned over to the defendant. His grand jury testimony was turned over. His record was turned over. He had the allegations that make him a part of a bad gang are things that happened in 2007, not at the time of trial, 2 years earlier.
But doesn't the affidavit make reference to the victim in this case?
It refers to the victim
And
as the victim of a
As a member
murder.
of the gang.
It says that he is associated with this gang. I'm not sure that it says he's a member of the
A
gang.
shrine was erected
It
to
says
him?
a shrine was erected where he was murdered, but the defendant misrepresents that affidavit and calls him a founder and leader of this gang. And that's not what the affidavit says. And there's nothing to indicate that in his record or in any of the police reports that's put up there. The victim's record at the time of his death, he had once been sent to jail. He had been arrested in some matter, spent 19 days in jail. It was resolved as a not guilty of assault with a dangerous weapon, guilty of disorderly conduct. He had various other matters that resulted in quaffs and dismissals, but that's his only conviction, is a disorderly conduct. This is the leader of a great, big, bad gang, according to the defendant. But that's the record, and that's what was turned over to the defendant before trial. So he knew exactly what it was, and he knew the victim personally. He had met with him that day.
But
He
there was
went- why did he go
disagreement.
down there?
Wasn't there disagreement about whether or not the victim was a member of the KST gang?
There was no disagreement that he was there with members of the gang.
But
There
that
was
he
much
was a
testimony.
member-
There was
That he was a member of the gang.
None of the people there said that he was an official member of the gang, but they said that there are no
But
official
Officer
membership.
Slattery,
They said
Lieutenant
there was-
Slattery says in his affidavit that he was a member. KST member Joseph McDaniels.
Yes. Mr. Slattery, Lieutenant Slattery says that. However, this isn't a contradiction that has a lot of meaning if it's treated as a contradiction, because everyone who was there alive to testify said that they were either members of or associated with or grew up with and were hanging with on a regular basis together. So
But not as a gang, just as a group.
Friends.
they weren't accused of having done anything there, you know, in these meetings at that time. In the years that passed, some of them turned out to be serious offenders and were prosecuted as such by the federal government.
But doesn't the Commonwealth in its closing argue that the victim was not a big bad gang member?
That's correct. And
And-
they also
and-
said that there is no gang motive for what happened here. And that's also what they said. This case, that it said the defendant is trying to paint him as a big, well, he's big, but a bad gang member. Okay, whatever that means. We've heard what's there. Nothing was introduced to support that, and the Framingham police have nothing to support that, and they don't say that. All they say is that he was a person in this KST group who was murdered on October 7th,
No,
2003.
they say he was a gang member.
Said he
The-
was
Lieutenant
was
Slattery
with
says he
it.
was a
He
gang
says it's a
member.
gang member. And if this jury, the judge has to conclude, there was a substantial risk that they would have come back differently if they had settled that question of someone who is walking with the gang and is with the gang and is friends of the gang and is a big guy and is the guy who's called out when the defendant comes out there. Yet it makes a difference whether he's a card-carrying member of a gang that doesn't even give issue cards?
You know,
If they're
one
not
of
so organized as that?
One of the problems here, of course, is that the judge who decided this motion was the trial judge.
Yes.
And got to see very directly how this issue might have played out and what the real issues and nuances of the trial were. And I guess to her, this would have been very important in how the jury viewed the witnesses that testified. And how can we say, oh, no, it's not all that
Well,
important?
I think that the judge, in all frankness, is a bit misreading what the lieutenant is saying. Now, the lieutenant is writing to make a gang statement so that the federal court will hold these people that he investigated later on in federal custody, and he makes it sound bad. But if you look at this affidavit with a critical eye,
You're not suggesting that he's embellishing or
I'm not saying that-
telling the truth.
No,
Everybody
I'm
concedes the
I concede
truthfulness of
that
the
what
affidavit.
he does say is true. What he doesn't say, though. And what he doesn't say is why these individuals at this trial, the victim, Anthony Campbell, Jamal Waters, and Damon Bonner, at the time of this trial, the police knew them to be a big bad gang, those individuals? Are they to carry on their shoulders the burden of what other people are going to do later on?
But you have to, I think what the trial judge appears to be doing here is threading together the misinformation that was allowed to be testified to without contradiction based on information that at least some members of the police department had at the time, that this was a friends from childhood hanging around, you know, shooting hoops type of organization.
None of these, no. The only thing that came out of anyone's mouth other than an attorney who said that this was no basketball group is one of the witnesses who said, one of these guys I met, Paul Purvis, who was with the defendant, a cousin of the defendant, says, I met him playing basketball. And from that, we come back and say, well, these are no basketball team people. You see,
But there was other testimony
the argument
about
is the argument of the
T
attorneys
wasn't
is not the evidence.
thugs. There was other testimony, that was just a piece of it, about the nature of the organization.
There really wasn't many questions about the nature of the organization. You know, one witness said, I don't like to be, you know, it's not a gang. That's Anthony Campbell. Anthony Campbell has no record. He is the 17-year-old cousin of the victim who went down there. From his point of view, how would he know that this is a gang? He's never seen anybody do anything. And so he answers that question that way. And I think a jury looks and sees these witnesses and they make that assessment. Jamal Waters came up there and says, KST? Yeah, I have a KST tattoo on my neck. Anthony Campbell's there saying, you know, when I drove my cousin to the hospital, the police took me down at gunpoint and handcuffed me. Same thing that Damon Bonner says. They were down there and saw this. They were there waiting for a fist fight in the streets. Now, this is not like the basketball teams that I belong to. And I don't think any of the jurors are looking at this and hearing it, only saying, all I'm going to go by is the words I hear. They're looking at these people, too, and hearing what they're saying. But what's important is, I think here, what did these witnesses actually say? How important are they to the case of the Commonwealth? This case turns on what the defendant said to the state police trooper, Richard Monahan, where he said that I shot him, and I went down there, and unlike any of the other witnesses, whether it's the witnesses of people who came with the defendant and were supposedly not KST, not part of it, see, this case didn't get into there's two rival gangs here, or there's some gang motive that's going to be the cause of this case. That's not in that's not in the affidavit. It's not in any of the material that we turned over. There's no support of that for at all. And that really didn't end up being the defense. I think that this case left questions as far as why did this happen. This looks like another one of these senseless activities where someone came down there with a gun and shot somebody when maybe everybody there was thought, well, there's going to be some argument or a fist fight or this or that. One person on one. We don't know what the reason of it is. They were joshing before in the afternoon about you're going to rob me. But what brought the defendant down there that night with three other people and to call out? The victim didn't seem to need any specific urging to walk out in the street and face off one by one with the defendant. That's what the jury heard. Now, what did they hear from the people who were there on the street waiting? Well, I said Anthony Campbell, the cousin who drove him to the hospital, said, I saw the defendant shoot him. Jamal Waters, somebody in a hoodie shot him. I don't know who that was. I don't even know who was there. He didn't even say the defendant was there that night. Are you going to impeach him by making him, this is my KST tattoo on my neck? What more did the jury need to hear about him? Damon Bonner, the person, the third witness that was there, well, he actually wasn't there. He says, I was off running an errand, driving one of the other guys off to his house, and when I came back, I found out that the shooting had happened. He didn't see the defendant there that night. He didn't say anything about that. But because he later gets indicted by federal court, that would have made a difference to the jury.
Counselor, can I ask you, the motion for new trial was filed with this affidavit that had been filed in the federal court. Procedurally, what happened next? Did the Commonwealth ask for an evidentiary hearing?
The Commonwealth, well, the defendant made a request for extensive discovery, not discovery that had been requested before, specific as to everything that the Framingham police knows about the victim,
Right.
which had been turned over, everything that the Framingham police knows about KST, the gang, without regard to who they're talking about, and everything that they know about this federal investigation that's gone on. The Commonwealth opposed that. The judge denied that. The judge said that I can make a decision on this case simply by reading the affidavit of the lieutenant. And so there was no evidence was taken. There was no further discovery.
And you didn't offer any further.
I didn't offer any at that time. I said that the affidavit is not sufficient to warrant a hearing and not sufficient to warrant the discovery or the relief. When the judge made a ruling saying this is what the affidavit tells me,
But there was a hearing, it was just a non-evidentiary
there were
hearing.
arguments. Yeah, we had arguments on two days, and that was it as to what is the significance. Because the defendant was also raising a lot of general, motion for new trial types of arguments. The Commonwealth, once the motion was allowed, asked for reconsideration, saying if you look at the information that is in these types of intelligence files, it does not support the conclusion that you're drawing, that these individuals, the Framingham police had information about that would really be significant to a jury. And here is that information. Now the defendant says we're not entitled to even give that over. I don't know if the judge read it or not read it, but I think that she erred if she didn't read it, because she has to know specifically. She can't just look at a vague affidavit as to the individuals. It's not vague as to general allegations about a gang, but as to these individuals, it's very vague. It doesn't mention them. It doesn't say they did anything wrong. And to draw the conclusion that Framingham police had information about those people was wrong. And if you look at the
All right,
files,
thank you,
that's
Counsel.
it. Thank you.
Please the court, I'm Ruth Greenberg. I'm here on behalf of Eric Murray. There's some sense that I'm here on behalf of Judge Hamlin and all the beleaguered justices, hard-working beleaguered justices of the Massachusetts trial courts. I don't think we're really here to discuss what Jamal said. We're here to discuss what's the standard of review on the granting of a motion for a new trial by a trial judge who was the trial judge. And that's what Judge Hamlin was here. The standard of review is abusive discretion or error of law. There's clearly no error of law. A judge wrote a beautifully researched, the judge had 2 years of hardworking law clerks, wrote a beautifully researched opinion. She did not, as Justice Lenk pointed out through her questioning, grant this motion based on any kind of adjutant material, and the adjutant discussion is entirely a red herring. She granted this motion because the Commonwealth's witnesses could have been impeached by evidence of the existence of the gang KST. And what we have in Lieutenant Slattery's affidavit is that witnesses are hesitant to give information about crimes involving KST because they fear retribution. That's in the Commonwealth's record appendix at page 73. We have, in general, KST members and associates refuse to cooperate, regularly engaging in acts of intimidation to maintain forced silence. He believes that Lieutenant Slattery's failure to cooperate demonstrated determination to handle violent disputes on their own criminal activities, and Lieutenant Slattery also describes gang-related activity, which exactly corresponds with the defendant's theory of the defense.
So tell me how this could have been used properly in your defense.
Well, first of all, I want to, if you'll forgive me for not answering your question for just one moment.
Sure. I'll come back to it.
Yeah, the person that I needed to persuade was Judge Hamlin. And she was there, and she looked at the witnesses, and she looked at the jury looking at the witnesses, and she looked at the jury watching the ADA making the closing argument. So it's Judge Hamlin that needs to be persuaded that these witnesses who testified as to what happened could have been impeached by the fact that they belonged to a gang whose credo was lie in court, and were also members of community where if they didn't say the right thing, they would be hurt or killed. So that's definitely, as Judge Hamlin properly found, it goes to bias and it goes to credibility. And every witness in this case has a bias and a credibility problem because of the influence of KST in Framingham. And that's what Judge Hamlin, who sits in the Middlesex County Court, who saw the witnesses, who saw the people in the public area of the courtroom, who was there and had opportunity to observe and to reflect, decided. And under Commonwealth versus Tucheri, cases like this, which are essentially Brady-Akers claims, the trial judge has extra discretion. She doesn't have to even find a constitutional violation. And the law is clear in Tucheri that even if the 5 of you wouldn't have agreed with her, nonetheless, her opinion is given deference unless there's an error of law or an abuse of discretion. Abuse of discretion, and this is my first red brief in 18 years of this court. I have been told what abuse of discretion means. It means no rational judge acting conscientiously, unless it means no conscientious judge acting irrationally. It means the judge had to have done something. She had to either not be conscientious or not be rational. She was clearly conscientious. She applied the correct legal standards. She reviewed the record. She sat conscientiously through the trial. There's no evidence to think she didn't. And she wrote a lengthy and well-considered, well-researched opinion. She was conscientious. Was she irrational? Clearly not. It might be one witness by one witness. Maybe the DA has an argument, and he made it. And the trial judge who was there rejected it. So the cases are legion. It's up to Judge Hamlin. It's up to the judges of the trial court who were there, particularly in cases like this where evidence was not provided. With respect, I have to say, though, with respect to the defendant's burden of showing the level of exculpatory information, I filed motions for discovery in this case. I asked to depose Mr. Slattery. I said, let's find out what Mr. Slattery knew and when he knew it. Let's find out what Sheila Calkins knew and when she knew it. Because the Operation Thunderdome was ongoing, and they didn't decide to have Operation Thunderdome just because they felt like it before the operation began, which involved the Framingham Police, the DEA, the FBI. It was a big deal. I asked, let's depose him. Let's cross-examine him. Let's find out who knew what and when they knew it. And the Commonwealth said no. The Commonwealth said, you can't have that. You can't have the basis. And the judge said, the Commonwealth, the judge ruled, I can't have it. And then she said, I'll decide on what I have. So I can't be faulted now. The defendant cannot be faulted for not presenting how Mr. Slattery knew what he knew when the Commonwealth objected to me knowing it and objected to an evidentiary hearing on it and objected to me cross-examining. That subsequent to trial submission of the Office of the District Attorney is unprovenanced. It's unexamined. I don't know what it is. It's not the 3 state and federal agencies who were involved reports. We don't know what's there and what's missing. It's too late. It's late, it's short, it's unprovenanced. We don't know what it is. All we know is I asked, they said no. The judge said, fine, you don't need it because what I have here, I know Lieutenant Slattery would say they intimidate witnesses, they beat down people, they've been a gang from forever. Joe McDaniel is a member, and so are all these witnesses. And what Judge Hamlin says is the fact they all lied about it would have made a difference in this trial. All those lying witnesses, we don't know what happened on that day. The jury, it would have, as a substantial risk, that had the jury heard these guys come from a culture which is the obstruction of justice, that we would have had a different verdict. And that was Judge Hamlin's ruling after being there. So in the absence of an abuse of discretion, and there is no error of law, and the Commonwealth alleges none, in the absence of abuse, the court needs to uphold the granting of this motion for a new trial. That's my argument.
All right, thank you very much.
I didn't get a question to answer to my question.
Please, I'm sorry. I'm happy to talk for my...
No, so explain to me. I understand what the standard is, but I'd like to know how, as a practical matter, would this evidence have been used at trial if it had been disclosed?
Okay. When we asked, we were permitted to ask, are you a member of the gang KST? And the guy with the KST tattoo says, there is no such gang.
Okay.
All right.
That's what the testimony, there is no such gang?
Yeah, there is no gang. We're a bunch of friends. We hang out on the block. We're the Kendall Street team. We're friends. There is no gang. So, there was, the extent of the admissibility of gang-related evidence to show motive is briefed pretty extensively in the motion for a new trial, which the judge reviewed. The discretion to admit gang-related evidence for motive and on the issue of first aggressor, but also on the issue of credibility, on the issue of bias. A trial judge has extraordinarily broad discretion. I know you have other cases this morning on what gang evidence is admissible and isn't, but it is sufficient for the purposes of this motion to say that a judge has broad, if not unlimited, discretion. And Judge Hamlin was the judge, so she knew what her discretion would have been on this issue. She knew what she would have decided because she was there, saw the witnesses, saw the trial. And that's one of the reasons why why the standard is defer to the discretion of the trial judge, because she knew what she would have let in. And we can't, but she does. I would be happy to take more questions. I'd love to.
No, I'm just, some of the witnesses that testified were not, as I take it, even in Slattery's affidavit, identified as gang members. Am I wrong about that?
Judge Slattery's affidavit was, Mr. Slattery did not prepare this affidavit in support of my motion for a new trial.
No, I understand that.
Okay. The gang membership of the witnesses in this case, some of them definitely were, even though they weren't named. They had tattoos, they had insignia, they were rumored to be and known as. The level of proof was very difficult because the information about gang membership was not in the hands of the defense. It was in the hands of the Commonwealth and not disclosed. That's the issue. In the next trial, it'll come out, we hope.
Okay, thank you, Counsel.
All right, thank you, Counsel.
Thank you, Judge.
Good morning. I'm